Letters of administration. What the heck is that? A lot of people, when someone has passed away, they've heard of the term probate. Probate is the process of taking somebody's will, going to the court, and having the court say, yes, this is in fact the last will. These are who the beneficiaries are. This is who's allowed to sign. These are the assets. These are the debts. The court goes through that and issues an order allowing for all those things, and that court order is called probate, a grant of probate. Now, when we're dealing with a letter of administration, it's a similar concept to a grant of probate, but that's for a situation where a person has passed away without any will. We call that an intestacy. The estate is intestate. There is no will directing who gets what. So what happens then? Well, the government has set up laws, legislation, which says who gets what in those situations. Typically, it would be in order of closeness of blood relationship. Often the spouses will be first, children, then parents, siblings, cousins, and so on and so on. The administration process for a letter of administration is doing the application to the court and saying, here's all the debts, here's all the assets, here's who's wanting to administer the estate, make sure everything's done properly, and making that order to follow the rules that are set out in law. The process is not necessarily hard, it's not any different than probate, the forms are different, but the process is essentially the same. Now, if you are managing the estate not as an executor, but in charge of the estate under a letter of administration, then you're going to do the same things as an executor under a will would, or under a proper probate situation. You're going to make sure that you gather the assets, keep everything safe, make sure you get a list of all the beneficiaries and who gets what, and you're just going to manage everything. Again, you don't have to operate alone. You can work with the lawyer to make sure that you're following the process. And once we're talking about lawyers, if you have to apply for a letter of administration, talk to the lawyer first. It's often a no-charge consultation over the phone, 15-20 minutes, because sometimes you won't have to do anything. The assets of the estate are such that there's no requirement to do that next step. So for instance, if a person owns real estate, they own land, and it's just their name on the land, then you're going to have to administer the estate with the letter of administration. If they have large amounts in their bank accounts, they'll have to do that. But if everything in their accounts, their bank accounts is in joint with somebody else, their home is owned jointly with somebody else, or they don't have a lot of assets, like less than $5,000 in a bank account, you may not have to take that step of going to the court for letters of administration. Don't operate on your own, especially when it costs you nothing to reach out. We're here to help to make sure you keep yourself out of trouble.